This is the introduction to a series of posts on U.S. immigration and citizenship. The full post will appear on my Substack account. The URL is on the screen. Before we start, let me be clear. I'm not a lawyer. I'm especially not an immigration lawyer. So if you need advice on that, you need to look somewhere else. I am not a politician. I am not working for any organization that has an axe to grind regarding U.S. immigration policy. I am a historian, and I'm doing what historians ought to do, giving you the past as context so that you can better decide what to do in the present and the future. This series of Substack posts consists of a selection of entries from my works in progress, timeline 1700 to 1900 and timeline 1900 to 2021. We will be looking at provisions of the major immigration laws, plus the historical context in which they were passed. Over the past centuries, why did people want to come to America? Did those who had already immigrated here encourage new arrivals, or did they try to keep them out? And if so, on what grounds? Trigger warning. U.S. immigration law often smacks of collectivism. Over the course of nearly 250 years, Congress has shown bias against many races, ethnicities, religions, and even sexual preferences. So let us stipulate right here that such a bigotry is very, very wrong. If I take the time to rant about it every time it comes up, these posts will go very, very long indeed. Spoiler, big surprise to me in researching these posts was how unsystematic the laws that govern U.S. immigration and citizenship are. They are almost always a reaction to current hot topics. No anarchists, no prostitutes, no cheap labor. There is a lot of spur-of-the-moment decision-making and very little discussion of moral and political principles. For example, who are we as a nation? What do we want to become? What sort of people, what sort of minds, with what sort of basic premises do we need in order to make that happen? The point of studying history is that it can help us answer questions like those. It lets us see what's been tried, what succeeded, what failed, what's relevant or irrelevant, and what the salient issues are. Therefore, I'm going to postpone discussion of proper immigration policy until after we've looked at a couple hundred years of historical context. As I was researching these posts, I also realized I did not know the legal meaning of many of the terms that kept coming out. On the assumption that some of you don't either, here's a short glossary. First, citizens. The current rights of U.S. citizens include voting in federal elections, running for office, serving on juries, entering and leaving the U.S. without restriction, and full access to federal benefits such as Social Security. How does one become a U.S. citizen? First option, one that applies to most people, is a birthright citizen. Generally, a person is a U.S. citizen if he's born within the territorial limits of the U.S., that's called jus soli, the right of the soil, or if he's born elsewhere with at least one parent, a U.S. citizen, that's called jus sanguinis, the right of blood. But a child born in the U.S. is not a U.S. citizen if his or her parents are foreign nationals, such as diplomats who are not subject to U.S. jurisdiction. That's generally accepted, but a much more disputed case of birthright citizenship, one that has been under debate for more than a century, is whether a child born in the U.S. is a citizen if his or her parents are here illegally. This is a 14th Amendment issue. 14th Amendment dates back to 1968. We will return to it in the posts on the 19th century and at the end of this series. But meanwhile, we move on to the other method of citizenship, naturalized citizenship. A person of a different nationality can become a U.S. citizen if he or she follows the required procedure, which includes a period of residence in the U.S., around 5 years, and taking an oath of allegiance to the U.S. Then there are American nationals. American nationals owe permanent allegiance to the U.S., but until or unless they become naturalized citizens, they do not have all the rights to full citizenship. For example, an American national cannot vote in a federal election. American nationals currently include people born in American Samoa or on Swains Island, which are overseas territories of the U.S. American Samoa is way over there. Swains Island is right next door. People born in Guam, Puerto Rico, and the U.S. Virgin Islands were formerly American nationals, but they are now U.S. citizens by birth. The next category is immigrants or aliens. In immigration law, aliens and immigrants are overlapping categories. An alien is anyone, anywhere, who is not a U.S. citizen or an American national. An immigrant is an alien who comes to the U.S. hoping to settle here. Today, many people use the term migrant as a synonym for immigrant. That blurs the crucial distinction between someone who's wandering from place to place within a country and someone who is entering a country with the intention of changing his residence and or his national allegiance. So in these posts, I always use the term immigrant. Let's look at the subcategories. A legal alien is an immigrant who's entered the U.S. with proper documentation. Usually that means a visa issued by the U.S. government. There are different categories of visas, which, if you want to pause the video, you can see them on the map. Then there is the category of asylum seeker. Those who are granted asylum in the U.S. are protected from deportation to their home country. They can legally work in the U.S., they can petition for immediate relatives to join them, and they can apply for some public benefits. They can also apply for a green card, which comes up in a few minutes, and eventually for U.S. citizenship. A temporary resident or someone with temporary legal status has permission to live in the U.S. for a specific period and under certain conditions. Examples are those with visas as students, as specialized workers, or as tourists. Those who are seeking asylum are also temporary residents pending a decision on their case. People who file under DACA, the Deferred Action for Childhood Arrivals program, instituted in 2012 under Obama, are also temporary residents. Temporary protected status, TPS, applies to those whose home countries are experiencing extraordinary conditions such as war or natural disaster. Those with temporary protected status cannot be deported and they can work legally only for a certain amount of time. Temporary resident status and TPS do not lead directly to lawful permanent resident status or to citizenship. Lawful permanent resident, LPR, is also known as a permanent resident alien, so still not a U.S. citizen. This status can be acquired via family sponsor, a job offer from a U.S. company, or 1 year after a grant of asylum. The symbol of LPR status is a green card. A lawful permanent resident can stay indefinitely in the U.S., can work legally, can travel outside the U.S. for up to a year without a reentry permit, can apply for certain government benefits, and is not liable to deportation except, for example, if convicted of a crime. An LPR cannot vote in federal elections or hold most public offices. Being an LPR, having a green card, is a necessary step before becoming a naturalized U.S. citizen. And finally, there are illegal aliens. Those are immigrants who have entered the U.S. without proper documentation. They do not have any of the rights of U.S. citizens, such as voting in federal elections, working legally, accepting federal benefits, etc. In March, April, and May of 2025, we're going to look in detail at U.S. immigration laws and their context. The rest of this video is a brief summary of what we'll see in those posts. Before we dive in, 2 images that give you a quick overview of U.S. immigration. This graph begins at 1820 because we don't have reliable data before that. Again, pause if you want to look at this and think about when the world wars happened and Civil War and so on and so on. The other interesting graph is this one, immigration by national origin. That medium blue color is Europe. Okay, so here's our summary of U.S. laws on immigration and citizenship. The U.S. sometimes went whole decades without a new law on immigration or citizenship. So in this summary, I'm just giving you dates for the periods when major laws were enacted. In 1790, just after the government established by the Constitution begins operation, Congress sets requirements for naturalization, citizenship. It sets them at 2 years residency for any free white person of good character. The only white people excluded are those who were proscribed for fighting on the British side during the Revolutionary War. In this early period and for almost a century, most of the immigrants who come to the U.S. are hoping to become farmers. In 1795 to 1802, Americans are concerned that the U.S. might become enmeshed in the French Revolutionary and Napoleonic Wars. Congress changes the residency requirement for naturalization from 2 years to 5, and then to 14, then it drops it back to 5. In 1864, during the Civil War, Congress officially encourages immigration for the first and only time in U.S. history. It does so by allowing immigrants to pledge up to a year of future wages to pay their passage to the U.S. The Civil Rights Act of 1866 and the 14th Amendment, ratified in 1868, allow blacks to be citizens. This is the birthright citizenship that I mentioned earlier, which we'll be coming back to. In 1875 to 1882, Congress passes laws that exclude Chinese, who are seen as competing with U.S. citizens for low-paying jobs. Also excluded, as of 1882, is anyone who might become a public charge, that is, who might require government support. This bars many impoverished would-be immigrants who hope to improve their economic status by working in the U.S. In 1891 to 1924, Congress sets out to restrict immigration in order to maintain the heritage of Americans as it was for 2 centuries, by skewing immigration to Northern and Western Europe. The means is quotas based on national origin of current U.S. citizens. That prohibits many would-be immigrants from Southern and Eastern Europe. Also excluded at this time are self-confessed anarchists and communists. In 1891, border controls are put into place by land and sea, which is why we have Ellis Island. As of 1917, an immigrant has to pass a literacy test in order to become a citizen. From 1924 to 1952, citizenship is extended to American Indians, to Chinese, Koreans, and Japanese, as well as to Filipinos who served in the U.S. military. This pretty much ends limits on citizenship by race, although the quotas on immigration by a national origin remain. In 1948 to 1952, following World War II, Congress allows entry of many displaced persons, refugees. As the Cold War begins, Congress also tries to exclude those who are suspected of radical left-wing politics, and it allows entry of asylum seekers from communist countries. In 1965 to 96, Congress ends quotas by nation of origin. It also increases the number of refugees and asylum seekers who are allowed to enter the U.S. Despite tighter border control, many illegal immigrants begin entering from Mexico. Congress sets rules for mandatory and expedited deportation. After 9/11, in an effort to keep terrorists out of the U.S., Congress establishes more stringent rules for identification of U.S. citizens. It votes to increase border patrols and sets new rules for deporting or detaining foreign nationals. Trump's Muslim ban of 2017 is part of this effort. And finally, in 2009 to 2017 and 2021 to 25, under the relaxed border policies of Obama and Biden, millions of illegal immigrants enter the U.S. via Mexico. The low estimates are 4.5 million, moderate estimates are 10 million, high estimates are multiples of those numbers. By virtue of the fact that they are illegal and undocumented, it's really hard to get numbers. Obama's Deferred Action for Childhood Arrivals program, DACA, attempts to deal with illegal immigrants who have lived most of their childhood in the U.S., but who were brought here by parents who are illegals. All right, that's the end of the summary. Coming in early March, we will look at settlements in North America before the U.S. becomes independent, and then immigration and citizenship laws during the early republic. About those posts, the first U.S. immigration law was all of 2 printed pages long. The 2005 Real ID Act is 93 pages long. I have included the URL for all the legislation so that you can read it in full if you wish, but the entries in posts that I'm doing are summaries, and they focus only on a few points. First of all, the historical context, what provoked this particular legislation. Then I look at restrictions on who can legally enter the U.S., special categories, exceptions to all the other restrictions. I look at border control. I look at deportation. I look at naturalization, who can become a citizen once they are in the U.S. legally. And then I look at the results of this particular legislation. So I hope you will follow me on Substack. These will be free posts. The URL is at the upper right. As always, thank you for listening.